Hello viewers, in this lesson we will learn about the relationship between banker and customer part 1. Objectives: to learn about the meaning, definition and the legal relationship between a banker and the customer. To learn about the duties and liabilities of a banker. To learn about the rights of a banker. Viewers, now we will examine the meaning, definition and the legal relationship between a banker and the customer. Meaning and definition. Lesson 1 contains a detailed analysis of the term and also the concept of banking. In general connotation, a person who carries the business of banking is called as a banker. There is no definition of a banker under the statute. Section 3 of the Negotiable Instruments Act 1881 states that banker includes any person acting as a banker. Subsection 2 to Section 2 of the Bankers' Books Evidence Act 1891 defines a bank as any company or corporation carrying on the business of banking, any partnership or individual to whose books the provisions of this act shall have been extended as hereinafter provided, any post office, savings bank or a money order office. Under the Halsbury's laws of England, banker means any person carrying on a banking undertaking as may be declared by order of the Treasury to be a banker. Under Section 7 of the Banking Regulation Act 1949, only a company registered under the Companies Act or a cooperative society or a statutory body like State Bank of India can carry banking business in India, and every such person must use as part of its name or in connection with its business any of the words bank, banker or banking. A customer is one who avails the services of a banker. This term is elaborately discussed in the next lesson 5. Legal relationship between a banker and the customer. Basically, the nature of relationship between a banker and the customer is contractual. This aspect was well analyzed in the English court judgment in Joachimson versus Swiss Bank Corporation. A banker carries all the functions of banking enumerated in the earlier lessons. A banker discharges multi-dimensional functions as a debtor, creditor, agent, trustee, custodian of valuables, as merchant banker and the like ones for his customers. It is also pertinent to note that the banker must invariably follow the Negotiable Instruments Act 1881 along with other banking legislations. All these issues are consolidated into a binding legal relationship as follows. Legal relationship as a debtor and a creditor. The money deposited with a banker is a debt for the banker. As long as the customer maintains a credit balance, the banker is the debtor and the customer is the creditor. But the customer remains as an unsecured creditor unless his deposit is insured by the Deposit Insurance and Credit Guarantee Corporation. On granting of loans, overdrafts, discounting of bills and like ones, the banker becomes the creditor. Depends upon the arrangement. The banker will remain as a secured or unsecured creditor. However, this relationship differs from similar relationship arising out of ordinary commercial debts, as in case of banks, the banker does not repay on its own accord. The banker is a privileged debtor. The customer, as a creditor, must make the demand for payment of his deposit in proper manner at proper place and time as stipulated under the banking rules. This aspect was well emphasized by the English court in Joachimson versus Swiss Banking Corporation. Legal relationship as trustee. Under the Indian Trusts Act 1882, a trustee holds money or assets of the trust to perform certain functions for the benefit of the beneficiary. With the multifarious functions of banking, the banker acts as a trustee for the money, the securities, as well as the valuables deposited by the customers. However, the banker is not the owner of the said properties, unlike a trustee. The customer continues to be the owner of his properties deposited with bankers. This concept of trusteeship was well analyzed by the Supreme Court in the case of New Bank of India Limited versus Pire Lal. The banker discharges fiduciary functions, and in that respect, he is a trustee. The Supreme Court distinguished the banker's role as a trustee from as debtor in Shanti Prasad Jain versus Director of Enforcement. Banker as agent. Today, all kinds of banks carry multifarious functions. The banker today buys and sells securities on behalf of his customers. The banker also collects checks and makes payments for various dues for his customers. Thus, the banker discharges the functions as an agent of his customer. In this regard, it is relevant to study the decision of Madras High Court in Travancore, National and Quilon Bank. Banker cannot refuse to provide services. Normally, a banker cannot refuse to provide its services to a customer unless there is a very valid reason. This point was well emphasized by the Supreme Court in Purewal and Associates versus Punjab National Bank. Advisor and manager. In the modern times, the banker also plays a very significant role as a financial advisor, tax consultant, manager to public issues, merchant banker, manager of mutual funds and properties, organizer of various issues and events, and the like ones. Bailey. Out of several services offered by the banks, today, one very important service is the safe custody deposits. In this regard, the banker is termed as the bailee, and all the provisions of the bailment under sections 148 to 181 of the Indian Contract Act 1872 apply to a banker. The Supreme Court in United Commercial Bank versus Hema Chandra Sarkar held that where the bank offers safe custody facility, its status is that of a bailee. Other services. Today, the banker offers multiple services like collecting checks, bills, discounting them, acting as executor and trustee, issuing travelers' checks, bank guarantees, credit cards, factoring, and various business as well as personal services. The legal status is determined based on the terms of the contracts on a case-to-case basis. Viewers, we will now learn about the duties and liabilities of a banker. In the modern connotation of banking activities, the banker discharges multifarious duties as enumerated under various legislations and also under global banking practice, and the failure of discharging those duties attract liability which are narrated here. Duties and liabilities related to payments. The banker is under a duty to honor checks under Section 31 of the Negotiable Instruments Act 1881 and other modes of withdrawal as per the bank's procedure. This duty is subject to the condition that the customer has sufficient funds with the banker either of his own or on any arrangement like overdraft. The customer cannot combine several accounts he is operating with the bank. He can demand payment on only that account in which he has sufficient balance. In this connection, it is pertinent to note that the Halsbury's Laws of England states that a balance at one branch of a bank does not entitle a customer to draw on another branch where he has no account or had overdrawn for different branches of a bank or, for this purpose, separate entities, though the bank may apply funds which it holds at one branch to meet an overdraft of the customer at another. Another important condition for making payment is that the check has not become stale, that is, presented after expiry of its validity time. Normally, a check is valid for 3 months from the date of its issue. Further, the post-dated checks cannot be presented before the date even there is sufficient balance in the concerned account. If the banker wrongfully refuses payments to the customer, he is liable for payment of damages to the customer under Section 31 of the Negotiable Instruments Act. Duties to honor court orders. The banker is duty bound to obey the orders of a court of law against his customers. Such orders could be like the attachment of the account of the customer in general or a garnishee order issued under Order 21, Rule 46 of the Code of Civil Procedure 1908. Garnishee order means an order of the court issued at the instance of the creditor called judgment creditor of the customer on the banker prohibiting him to make payments to his customer. The account of the customer under such an order remains suspended and the banker is duty bound to hand over the entire money in the customer's account to the judgment creditor in accordance with the court's order. The banker is also duty bound to inform the customer about the garnishee order or any other court order issued against him. If the orders of the court are disobeyed, the banker is liable for punishment for contempt of court. Duty to obey the orders issued by the tax authorities. The tax authorities can attach the credit balance of a customer if he defaults in making payment of the tax dues. As for example, an action can be taken by the income tax officer under subsection 3 to section 226 of the Income Tax Act 1961 for tax dues. The banker must comply with such an order, and if he disobeys, he will be liable for penal action. Duty to maintain secrecy of accounts of the customers. The banker is under a strict duty not to disclose the information about the accounts and details of his customers to outsiders. He should maintain strict secrecy of the same. Any violation of this principle results in causing breach of trust, and the banker is liable for paying damages to the customer. Under Section 13 of the Banking Companies Acquisition and Transfer of Undertakings Act 1970, the nationalized banks in India are required not to divulge any information about its constituents, except in circumstances in which they are in accordance with law or practices and usages customary among bankers. Thus, the general rule is that the banker can disclose the information about his customers only when it requires under law and under the practices and usages. Such a disclosure is termed as justifiable disclosure. Justifiable disclosure under law. The various laws warrant disclosure of information by the banks about their customers are the Income Tax Act 1961, the Companies Act 2013 and the earlier Companies Act 1956, the Bankers Books Evidence Act 1891, the Reserve Bank of India Act 1934, the Banking Regulation Act 1949, the Gift Tax Act 1958, the Foreign Exchange Management Act 1999, the Industrial Development Bank of India Act 1964. Justifiable disclosure under bankers' practices and usages. The standard practices and usages for justifiable disclosure are express or implied consent of the customer, references from other bankers, disclosure in order to legally protect the banker's own interest, rendering an opinion on the position of a customer based on his account, rendering a general statement without disclosing the actual figures. Duty to the public to disclose where a government official on his duty demands the furnishing of information or disclosure against a customer who is involved in activities prejudicial to the interests of the country, or where the bank's books disclose that the customer is contravening the provisions of any law, or where heavy funds are received from foreign countries by the customer. If the disclosure by a banker is not justified, then he will attract a heavy liability. The liability is towards the customer by way of paying damages and also towards the third parties, which also results in paying heavy damages where the banker furnishes any information to the third parties with the knowledge that it is false, and the third parties, by relying upon that information, suffer loss and damage. The famous decision of House of Lords in this regard is Headley, Bernay and Company versus Heller and Partners Limited. In this case, a firm sought some opinion about a customer, which is a company, from a bank. The banker opined that the company was considered good for its ordinary business engagements. The banker further added that the figure of £1 lakh, as mentioned by the firm, was larger than they were accustomed to see, and further stated that the opinion was given without any responsibility on the part of the bank. The firm had business dealings with this customer company and suffered a loss of £17,000 due to the winding up of the company. Then the firm sued the banker for recovery of the loss on the grounds of negligence and breach of duty. The trial court held that the banker owed no duty of care to the firm. The House of Lords upheld this decision and held that if the banker gives an opinion on the creditworthiness of his customer, his duty is only to give an honest opinion, and if the banker stipulates that the opinion is without any responsibility, he cannot be held liable for negligence. Liability for fraud, embezzlement committed by employees. The banker as an employer is vicariously liable for the misdeeds of his employees. The Supreme Court emphasized this point in State Bank of India versus Shyama Devi and in Bank of Bihar versus Mahabir Lal. Viewers, now we will learn about the rights of a banker. The banker is vested with legal and statutory rights to protect its interest. Some important rights are discussed in this lesson. Right of lien. The banker is entitled to exercise the right of general lien as provided under Section 171 of the Indian Contract Act 1872. Lien means right to retain the goods and securities owned by the debtor and kept under the custody of the creditor as a security for repayment of a debt until the debt is cleared off. The creditor can sell them also for recovery in accordance with the provisions of the Indian Contract Act. The status of a banker in case of safe custody of deposit of movables is that of a bailee, and he cannot exercise this right in such a case. If the banker allows any loan on the ornaments or movables, he is called as pani, and the provisions under sections 172 to 181 of the Indian Contract Act apply to bankers also, along with other kinds of panis. Section 171 empowers the bankers to retain as a security for a general balance of account any goods bailed to them in the absence of a contract to the contrary. The banker, under the provisions of sections 172 to 176 of the Indian Contract Act, can sell the goods by either taking the help of a court or giving reasonable notice to the customer, called as paner. This subject was well emphasized by the Supreme Court in Lallan Prasad versus Rahmat Ali. However, this right is not available if the goods are entrusted to the banker as a trustee or an agent, or a contract exists between the parties which is inconsistent with the banker's rights as stated afore under section 171. Basically, the right of lien can be exercised only if the possession, whether constructive or actual, of the movables remains with the banker. In case of safe custody deposits, documents deposited for any special purpose, like the case of bills of exchange, documents or valuables left with the banker negligently, securities held in trust, and where the banker exercises the right of set off, this right of lien cannot be exercised. Right to set off. Right to set off means adjustment of mutual claims. The banker is embedded with legal as well as statutory rights to recover its monies from the customers. The banker can combine two or more